Dismissed.
Dismissed.
Dismissed. Yes, dismissed.
May I please, Your Lordship, I beg to mention item number 15, Lordship.
50.
15, 1-5. I have filed an IA for impediment and respondent number 2, Lordship. We have filed it today. I've taken the consent. Can it be on Friday, Lordship? The IA will also be listed.
Lordship, there is an interim order. Interim order may continue, Lordship.
Learned Counsel Mr. V.A. Chaudhary.
Lordship.
You are representing somebody?
Lordship,
NLP
no, I'm for the respondent. For that, we have filed an IA to be impeded and
Mr. V.A.
respondent number 2.
Chaudhary has submitted that he has filed an IA for
Impediment and respondent number 2.
impediment or respondent.
Respondent number 2, Lordship.
Respondent number 2, heard Miss
Kalyani De, on behalf of
K.
Mr.
Day,
NLP
on
Chaudhary.
behalf, oh no, your name is Day, no. Heard Miss K. Day. This is the matter on Friday, 30
Interim order may
interim
continue,
order
Lordship.
shall remain in force till then.
Deeply obliged.
Deeply obliged.
I beg to mention item 32. It may be upgraded to 2 p.m., my lord. It will take hardly 5 minutes because we would submit that the matter may be sent back to the court below for
Yes.
before the civil court.
Item number
32,
32.
2
Huh?
p.m.
Hearing matter. Yes, yes. At 2.
May it please, Your Lordship, I beg to mention one IA, Lordship. It was supposed to be listed after 2 weeks, but not listed yet, Lordship. IA for conjunction of delay. The matter may come on Wednesday.
Roster is either, remember?
May I please, Your Lordship?
29. Okay.
May I please, Your Lordship? I beg to mention item number 34, Lordship, the bail hearing matter. The coordinating council out of 34.
34.
Out of station. Can you on next Monday, Lordship?
Learned Counsel Mr.
Arhok on behalf of N. Hassan.
R. Hawk on behalf of N. Hussain Hassan has prayed for adjournment. List the matter.
Obliged, Lord.
You have bail hearing. Do you have the CD, LCR or anything? Okay, sir.
May I please, Your Lordship? I beg to mention item number 16, my lord. Hence, matter will be taken after 2 weeks, my lord. This is scan copy online. 16.
Learned Counsel Mr. G. Bora has prayed for adjournment. List the matter on
After 2
9
weeks.
June.
2 weeks.
2 weeks, did you? 9 June is 2 weeks.
Obliged, my lord.
If I may, my lord, I beg to mention item 38 of the supplementary list.
38.
Yes, please. 38.
I am for the respondent, my lord.
Okay.
I have some urgency. That is why this case has been fixed. So a date may be fixed.
Learned Counsel Mr.
G. Imtiaz, my
G.
Imtiaz, my lord, on behalf of Mr. A. Iqbal.
Imtiaz on behalf of Learned Counsel, Mr. A. Iqbal with the consent of the other side, with the consent of Learned Counsel Mr. S.K. Ghosh, representing the respondent has prayed for adjournment. List the matter on 5th June.
My lord,
5th June.
Deeply obliged.
much obliged.
Yeah, please, Your Lordship. I beg to mention item number 5. May the matter be taken up after 2 weeks.
Learned Counsel Mr.
P.D. Chaudhary on behalf of Senior Counsel Z. Kamar.
P.D. Chaudhary on behalf of Learned Senior Counsel Mr. Z. Kamar has prayed for adjournment. List the matter. Are you on interim?
No, my lord,
No.
it's a Zimma petition.
List the matter on after list the matter after 2 weeks.
Obliged, my lord.
May I please, Your Lordship, item number 19, LCR is received but not take with the record. So kindly matter may be fixed on 29, 0 and 25 with record. 19.
When do you want?
Yes, ma'am.
When do you want? You're asking for adjournment, no?
Yes,
When do you want next date?
29.
29. Learned Counsel Mr.
HR Chaudhary.
H.R. Chaudhary has prayed for adjournment. List the matter on 29.
Obliged.
May I please, Your Lordship? Lordship, I beg for listing a RFA matter, Lordship.
RFA?
Yes, as per roster.
21.
Lordship, next week, any date, Lordship.
Next week's also fine. Yes.
Next week.
Please, Your Lordship,
Hmm.
as regards item number 5, I'm
Five.
appearing for the state as a special PP in this case.
Hmm.
My name may kindly be shown in this case, was list.
And five to
Item number 5. And a date may kindly be fixed because I'll be out of station. Probably he had mentioned for 2 weeks time. A date may kindly be fixed. On 12th of June,
Okay. Learned Counsel, Mr.
J. A. Hassan. J. A. Hassan.
J. Hassan has submitted that his name may be registered to reflect the name of Mr. J. Hassan.
J. A. Hassan.
J. Hassan, special PP.
Special.
In the cause list the matter on date. 12 June.
Children. Hello.
Hmm.
So I'd like to mention regarding item number 4, Lordship, of
Hmm.
today's list. Today I have some personal difficulty, Lordship. So can it be fixed any week, next week, Lordship, any day?
Learned Counsel,
I'm
Mr.
okay.
A. Ahmed with the consent of the other side.
But I'm okay for respondents,
Yes,
otherwise I did not have, I had some objection, but a date may be fixed, my lord, since he has some difficulty.
List the
Urgency is
matter on.
Urgent, so. Deeply obliged.
Interim order earlier passed, that
Oh.
may be continued, Lordship.
Interim order shall remain in force till then.
Obliged, Lord.
I'm deeply obliged, madam.
May I please, Your Lordship, I pray to mention for listing of criminal appeal 189/24.
Finding.
2nd June. Highly obliged.
Item number 1.
Records may be called.
Trial court records. And yes.
case, madam.
Sarsi submitted, so he's asking for records. NDPS.
Well,
Why don't you try? Why don't you try before the trial court?
Trial is going on, Your Lord. We have,
Trial is going on.
yeah.
Okay.
The main accused has been
Call
given.
for the scan copies of the trial court record along with the scan copies of the CD. List the matter of.
3rd June. Much obliged.
Item 2.
Wait, please, Your Lordship.
Hmm.
Lordship, the Carnatic Council, Mr. A. Ganguly is out of station, Lordship. Lordship, may please.
Your Lordship, last time also they have taken time, Your Lordship, and this time also without inform.
Lordship, one week.
Let me see. Let me check.
They are enjoying a stay, Your Lordship.
Stay since 2022.
Yes, Your Lordship.
But see, he is out of station. He cannot help it.
Let the matter come up on Wednesday, Your Lordship.
Learned Counsel, Mr.
G dash, Lord.
Huh?
Lordship,
Sorry.
G dash, Lordship, G dash.
He does. On behalf of Learned Counsel, Mr. A. Ganguly has prayed for adjournment. Learned Counsel, Mr.
I Hussein.
I. Hussein has raised objections stating that several adjournments have been procured. And the original and the impugned order has been stayed since 27/6/2022. List the matter positively on 6 June.
Much obliged.
Right. Your Lordship, can it be on after 7 or? Obliged.
Much obliged.
Item number 3.
May I please, Your Lordship? Lordship, in this case, a talk of amicable settlement is going on in the parties for some time.
He's saying no.
No, Your Lordship.
No.
My instructions are very clear. Your Lordship. There is no option of amicable settlement. They need to pay. There is a concurrent judgment, Your Lordship. 2 courts. The matter will be fixed for hearing, Your Lordship. 3.
You are representing or your senior is representing?
Senior is representing actually.
Senior.
So sometime maybe given
After some time?
after some.
Okay, after some time.
Or it will be fixed on another date, Your Lordship.
And
For
then
hearing.
Not for hearing. Has it been admitted?
Oh, no, Your Lordship.
The
That's not-
senior has to submit. So after some time then? Or another date?
Yes, Your Lordship. We are paying for another date.
another next week.
Okay, as agreed by Learned Counsel, both the parties list the matter on next week,
May
4th June for hearing positively. Or for hearing, positively nalai.
obliged.
Obliged.
Lordship, please.
What about the other side?
The issue is, my lord, it's a quashing petition, 323, 353, less than 3 years. There is an SOP of the government which says less than 3 years matters can be withdrawn.
Yes, I understand, but let the other side be here.
My lord, here, lordship may direct the breath.
At page 44,
Page 44, my lord.
yes, that. The SOP starts at 39,
SOP at page,
page 39, my lord.
yeah, less than 3 months, less than
Yes,
3 years.
and the
yes.
direction is at page 44. At the bottom, ma'am, it says that the government of Assam has collected from the Guwahati High Court, which reveals that there are 1 lakh so-and-so number of cases registered up to so-and-so, which can be withdrawn in respect of the above categories of cases, out of which cases falling under so-and-so cruelty to women will be excluded. State cabinet. This is the information that we are seeking, that's all.
Well, that information is required, my lord, whether this particular case is within the purview of that 1,18,000 case. But it can be verified from the registry, my lord.
So we'll wait today or we'll fix a date.
Lordship, is a person order, my lord, to verify registry cell would verify it, whether this particular case is within the purview of that, within 1,18,000 case.
And we send
If
a
it is,
report on.
Send the
then,
report, my lord, yes, then it'll be easy also for us to decide on that.
Learned Counsel, Mr. R.B. Pukon
Yes,
is present for the petitioner. Who's some learned additional PP?
absolutely.
Learned additional PP for Mr. J. Sutia is present for the respondent state. The petitioner is present before this court with a prayer for quashing the FIR dated 9/10/2014. Registered as GR case number 10451 of 2014 under section
323 and 353, ma'am.
323 and
353.
353 of the Indian Penal Code pending in the court of the JMFC, Kamrup M. The, it is submitted at the bar that
The SOP is at page 39.
the annexure 7 of the petition clearly reveals that certain cases can be withdrawn where the punishment is only up to 3 years or fine or both under the IPC, full stop. As this is case is registered under section 323/354 of the IPC, registry is to send a report if the present case arising out of Bhangagor PS case number 167 so 167/14 falls under the category which can be withdrawn. Okay,
Yeah.
this is the matter of. When do you want? This is the
Immediate
matter.
convenient to your lordship because the report has to come.
Then this,
Is 9th okay, my lord? In June, if it is okay. Should not be a problem.
9th.
It is not inconvenience to my lord.
9th of June.
9th of June, extremely great.
Item 7.
Lordship.
Senior,
No, lordship. Lordship, item number 2, the interim shall continue, lordship.
item number request interim order shall remain in force till the next date of listing.
Much obliged.
Maybe in respect of item number 7, lordship, on additional affidavit has been affidavit replies has been filed by the petition, lordship, which is not on record, I suppose, lordship. Though let it be call on record, lordship, and thereafter matter will be heard, lordship. My land print is there.
A date of maybe fixed, your lordship. A date may be fixed, your lordship.
One, a reply to the affidavit filed by respondent number 2 has been filed on Friday, your lordship, this Friday, but which is not tagged with the record, lordship.
Learned Counsel, Mr. S.N.
Krishna Treya, lordship.
Treya has submitted that and affidavit in reply has been submitted, which is not on record. Learned Counsel, Ms.
T. Ghosh.
T. Ghosh is present for respondent number 2 and learned additional PP. Mr. B. Sharma is present for the respondent state. Receipt to place the affidavit in reply on record, place the matter on data.
Lordship, can it be on 16th or
16,
20?
your lordship.
It can be 16th
Lordship,
or 20th.
20th or 16th June, any day.
16.
Interim order is there, lordship.
Interim order shall remain in force till then.
Obliged, lordship.
Item 8.
Yeah, please, your lordship. Lordship, by order dated 28/3/2025, lordship, one report was called for.
Do you have the report? This item will be criminal revision petition 95 of 2025.
Yes,
Zimmer
lordship.
report.
Number nine.
Zimmer report.
My lord. Today I have not received, my lord.
You have received?
Not received.
No, not received.
That report would be required, lordship, as because, lordship, in the report which has been submitted by the IO, he stated that vehicle is not required for further investigation, neither it is required for any other purpose. He cannot release the vehicle only because the vehicle is loaded with some petroleum chemicals. So regarding that, lordship,
Report as called for is
called?
not received. We should reminder list the matter on 5th June.
Yes, sir. Highly obliged.
Yeah, please, your lordship. Lordship, just now I have received your affidavit. I need some time to file my reply on affidavit.
Yeah, you'll need. Learned.
Interim is there, lordship. Interim is there.
Yeah. Learned Counsel, Mr.
R. Yasin.
Huh?
R. Yasin, lordship.
R. Yasin has submitted for time to submit an affidavit in reply
Reply.
against the objection filed by the respondent. Learned Counsel, Mr. A. Saha is present for respondent number 2 and learned additional PP. Mr. B. Sharma is present for the respondent state. I'll list the matter of 9 June will be fine.
Absolutely. Lordship, can it be fixed after 9 June?
Can
At least 4 weeks,
can be
lordship.
no objection comes to that side. 18 June.
Absolutely. Highly obliged.
Yes, yes.
In this case, my lord, the appellant has been, my lord, convicted under section 6, lordship, RI for 10 years, lord.
Not admitted. I think it is. not admitted.
I disposed of it. This is for admission, lordship.
But shown in the parliamentary disposal, no? I.
Huh? ये भी ले,
Oh, no.
ये लो kan. ये ले kon.
What about respondent number 2?
My lord, respondent number 2, my lord, not appeared.
Not touched. You'll have to issue notice. to
My lord,
respondent
my lord.
number 2. You
My
have
lord,
to issue
in
notice.
appeal, lordship.
Both.
Both, my lord.
My lord, delay condemnation, lordship, that was already my lord condemned, lordship.
Condone?
Yes, lord. Yes. Huh?
I don't have the order here.
Without admission, how it will be? My lord, delay was condemned, lordship. 16/5/2025, lordship.
This IA is for what? This IA is for bail?
Section 5, lordship, limitation act.
No.
Appeal admit quiz.
Suspension of sentence and bail. One IA is for suspension of sentence and bail.
My lord,
Now, there you'll have to issue notice.
my lord, I have no knowledge whether, my lord, it is admitted or not. My lord.
Your delay has been condoned,
My lord.
but appeal has not been admitted.
Yes, lordship, that is why, my lord, without admission, lordship, the bail is not, my lord.
No, you'll have to issue notice in.
Yes, lordship, in
main
IA plus, my lord.
Yes, main.
It may be
case.
first, it may be admitted, lordship. LCR may be.
We'll have to admit.
Yes.
We'll have to admit. This is a statutory appeal, we'll have to admit. Learned Counsel, Mr.
Ahmed Shah.
Ahmed.
Ahmed Shah.
Ahmed is present for the applicant. Learned Additional PP, Mr. B. Sharma is present for the respondent state. Petitioner, appellant to take steps to issue notice to the respondent number 2. Yeah. I have to clap for you. Na belakka dile. Huh? No?
Contribution of MSA facility.
Okay, I'll club the IA also. Together,
My lord.
same order.
My lord. Notice will go, my lord. Then
Yeah.
I will be considered after receipt of my lord.
Club to appellant stroke applicant to take steps to issue notice to the respondent number 2, returnable on data
My lord, no resisting, my lord. It will as per the act, my lord.
Okay, through the registry
Registry,
of
my lord,
this
then
court.
PP office.
Meanwhile, call for the trial court records, admit, list the matter on 12 June.
All like this.
Well, this is only application, Lordship, for filing appeal against acquittal, Lordship. So I think, Lordship, this first notices to go to the respondents, my lord, without hearing them, Lordship, because this is
SLP, you have
a
an SLP
NI
also?
case.
Huh? Leave petition, you
Leave
have a
petition,
leave petition also.
Leave to appeal against acquittal.
Yeah.
So already they are representing 1 Lordship and 2 from 2 to 5 Lordship, they issue notice. Lordship.
Learned Counsel, Mr.
M. Ahmed, Lordship.
M. Ahmed. Human item number
11.
is present for the applicant. To stop learned additional PP, Mr. B. Soma is present for the respondent number 1. Applicant to take steps to issue notice to the respondent number 2 and 3,
2, 3, 4, 5.
or 2, 3, 4, and 5. Returnable on
Let it be after vacation, Lordship, because
as usual process.
usual process.
As per usual process, returnable on summer vacation episode.
16 July. Item 12.
I for
May I please your lordship, the statutory appeal, the husband was convicted for 7 years under 404B and 498A 2 years, total 7 years, both will run concurrently. But my lord, I am placing a document, gist of the matter, my lord. Kindly see, there is absolutely no evidence. And my lord, those witnesses, they said they were hard.
conviction.
My lord, 7 years, my lord.
7 years. Your lordship may kindly grant the bail, my lord. Kindly.
Will-
All have, other family members have been acquitted. And my lord, medical evidence is that the heart
Committed suicide.
cause of the death could not be ascertained. And there is an allegation of administering poison.
Yeah, you have a ground. Let us call for the LCR.
Fine.
My lord, it is not a case of to be upheld by the conviction.
Huh?
Absolutely, there is no
Not required,
material.
Yes, required to hear any side except you. Learned Counsel, Mr. S.C. Biswas is present for the petition applicant. Oh, we'll club it together, we'll admit the appeal.
My lord, admit call for the record.
Admit, it is a statutory admission has to be done.
Club is present for the appellant stroke applicant. Learned additional PP, Mr. B. Soma is present for the respondent state. Petitioner, appellant stroke applicant to take steps to issue notice to the respondent. I don't know, like respondent. Meanwhile, call for the list. Respondent, you only the state is the respondent.
Yes. Other secretary, father is not
Admit the-
required.
Admit the appeal. List, call for the
Trial court record.
trial court records. List the matter on 12 June.
12 June.
Yes,
Will it come from
it will come from
Anyway.
which Karimganj?
12 June, my lord?
It will come from Karimganj.
Yes. Your place, my lord, I know. My lord, regarding IA, my lord,
I
Both I have clubbed it together.
I will be considered on the after receive the LCR.
I don't really a single query. I think that also I'll have to separate it, no? Yeah, I do separate query.
That will be ordered in the IA.
এই দুটা বেলেগ বেলেগ কৰি দিম
বেলেগ বেলেগ separate হৈ যাব।
সেপাৰেট কৰিব আগৰটো সেপাৰেট কৰি দিম
Obliged, deep block.
Item 30. May I appeal, Lord? Appeal against acquittal, my lord, in the case, my lord, in the entire judgment, my lord. PW 6, my lord, there is headmaster, my lord. Headmaster. He has he has proved the school certificate of the victim, my lord. But entire judgment, there is no any whisper about PW 6, my lord. Not a single word is mentioned in the judgment. It is a case of POXO, my lord. Normally, my lord, 164 statement and the my lord.
appeal against acquittal under
My lord,
under which is section
section POXO, my lord.
no that BNS
BNS, my lord.
I'll have to
413.
to whether SLP will be required or not, everything I'll have to read now. Because this is BNS, I do not know much. It's always new for me.
Yes, 413.
I mean, leave to appeal, not SLP. Leave to appeal will be required on. Under section 413.
413.
PW 60 swap headmaster. He proved that.
You are the aggrieved.
My lord.
You are the aggrieved.
Yes, my lord.
Informant or the
Informant. A notice may go, my lord. A notice may be go, my lord.
Yes. Notice to the accused.
Yes,
You will have
yes.
to issue notice.
Yes.
Appeal against acquittal, always
yes.
you'll have to issue notice.
Yes. Entire judgment of PW 6 কথা একো কোৱা নাই।
I'll just, wow, just a minute, I'll just read section 430. Yeah, I think. Informant is also the victim. Yes, learned counsel, Mr.
Yeah, ma'am.
M. Ahmed is present for the appellant. Applicant. Oh, you have an LP also? No, there is no LP.
No,
But why it is written as item number?
13.
Oh, okay. Is present for the appellant. Learned additional PP, Mr. B. Soma is present for the state. Learned appellant to take steps to issue notice to the
Upon the respondent number 2 and 3.
respondent number 2 and 3. To register post as well as usual process, returnable on. Call for the trial court record list accordingly. All right. Shall I admit it?
Yes.
Admit.
Publish.
Item 14.
Please, Lordship. Please, Lordship. Lordship, in this case, report was called for, Lordship. Today is third occasion, Lordship.
Item number?
14, 1-4.
Third occasion. Do you have the report?
My lord, today also not received, my lord.
What is it? What is your
This is
prayer?
the Lordship, impugn order is page 27, Lordship. This is my Jima petition was
Zima for
rejected.
what?
Vehicle, Lordship.
What vehicle?
Bolero, Lordship.
Transporting what?
Transporting NDPS, my lord.
NDPS,
21C,
Okay,
my
need the
lord.
report. We'll need a report. Report is called for its
Fine.
not received.
That's
We'll
why
give you
today is
a
third and fourth occasion,
we'll
Lordship.
give you
Report was
sufficient
called.
time. I
Fine.
think we are giving short dates, so
Yes,
report is
Lordship.
not arriving. We'll
Yes,
give you a 2 weeks time at least.
My lord.
Report is called for is not received. We should reminder list the matter on 2 weeks. 9 June.
Lordship, some
My lord.
short date, Lordship.
Short
Today
date,
is
then it
20
it won't come.
26, today is 26.
The report will come from which Thana?
See, Bhumi.
Sibumi, Karimganj.
Minimum 2 weeks.
Bas ho gaya.
Hearing?
Item number? Huh?
Over. 8 order. 9. Appeal is admitted on framing the following substantial questions of law. 1 and 2, huh? 1, 2, 3 and 4.
Hello.
All that sheet you have given,
Lord.
we have included everything.
Hello.
May I please, my lord, this is a regular bail application. My lord will find the FIR at page
But
13.
before starting my colleague's matter, in this case, charge sheet submitted, madam.
That was, even if charge is submitted, my lord, today
Then
he
we
has
will
completed
get the
56 days, my lord.
Huh?
So considering that, my lord, bail may be granted. Otherwise,
many
it becomes
days?
very difficult, my lord.
How many days?
56 days till today.
What is the offense?
Theft, my lord, theft of a truck. My lord, he has been arrested on 33, 2025. Till
Theft
date,
of
my
a
lord,
truck?
truck.
Or you approach the
No, my lord, may kindly grant bail because only 4
Where is
days.
the jurisdiction of court?
My lord, the Guwahati. Guwahati jurisdiction, my lord. Only 4 days left, my lord. That is why I am praying. Otherwise, I am not inclined to praise this honorable court. That is for sure, my lord.
My lord,
What about the appeal?
no. My submission is a charge sheet submitted, madam. They have appeared before the court below,
My
madam.
lord, only 4 days left, my lord. That is why I am praying. Otherwise, it would have been a long tenure of period that we will have to it. I would not have praised, my lord.
Some smaller object, then it was fine. You approach the
My lord, even the
jurisdiction of court.
truck has been recovered in this case.
Truck may be recovered, but
Well, considering that, my lord, only bail may be granted today because 4 days left, my lord. That is why.
Guwahati, why are you so tardy to get to the Guwahati?
Then again, my lord,
Sessions
then
court?
there shall be my lord, separate process that I have to initiate it. If the things could get little easier, so it would have been a great ease for me. That is why I am pressing, my lord. Otherwise, I do not have any intention to press. I never did it before, my lord.
Madam, within the period of 60 days, madam, charge sheet submitted, madam. And from the FIR itself also said that the truck was missing, madam. And they applied that, madam.
But truck has been recovered according to
The
him.
truck has been recovered, my
But
lord.
here only, madam,
My lord, that apart, my lord, so far as the forwarding report is concerned,
several persons.
I have been arrested on the basis of the statement made by the co-accused in this case. That is why I am praying.
No. You approach the jurisdiction of court. Learned counsel, Mr.
Be there, my lord.
BJK is present for the petitioner. Learned additional PD, Mr. B. Samay submitted as charge sheet has been laid against the petitioner being CS number
245 of 25. Dated 24/5/25.
The petitioner is at liberty to approach the jurisdiction of court and apply for bail, which may be considered by the court in accordance with law. In case bail is rejected, then you may approach this court.
Deeply over.
May I please, Lordship? Well, in this case, my lord, notice was issued, Lordship, and the CD was called for, Lordship.
You have the CD?
CD received, my lord, but madam, regarding the service, my lord, no office note, madam.
Office not here, sir. Ready to. 2 and 3 will, I think respond number 2 and 3 has to appear.
Yes, Lordship.
Awaited.
Awaited.
Steps have been taken, but nothing has been reported.
SR may be awaited, Lordship.
Okay.
Service
report on respondent number 2 and 3 is awaited. List the matter on details on 10 June.
Obliged, Lordship.
Item number 20 for orders. CD to be sent back or?
My lord, send back, madam.
Send back the CD and call for the uploaded CD.
My lord.
This is from which Thana will elongate the date otherwise?
My lord.
Which Thana?
My lord, from Morigaon, my lord.
Okay. 10 June 5.
That, my lord.
This is from Lahorigat.
Today itself you send back.
Lahorigat, yes, Lordship.
Is it a remote place?
Yes.
Okay. How long will you take?
18 June, my lord.
Obliged, Lordship.
Lordship, as per the last office note dated 9/12/24, several occasions have been
Item number?
20.
You're for the respondent?
Yes, Lordship, I'm for the respondent. Several occasions has been given for the appellants to file a new wakalatnama or engage in new counsel, but none has appeared so far. If you check the office note dated 9/12/24, last order dated 9/12/24, several
Yes.
opportunity has been given. Last chance was given. Lordship, the matter may be dismissed.
Can be dismissed, I think. Were they informed that petitioners were this appellants? Were they informed earlier about this
Lordship,
case?
a notice was also issued from the registry
Okay.
on
Where?
18/6/24.
18/6/24.
Yes. Lordship, may check office note dated 17/9/24 that the speed post was taken on 18/6/24 informing the appellants about the withdrawal of wakalatnama.
Okay. And the notice has been served. In office note dated
17/9/24.
17/9/24. Notice issued to appellants has not been received back. No leave. The notice has not been received back. So they may not be informed about it.
No, Lordship, after that, on the order dated 1/10/24 also, it has been given that no new counsel appears and filed wakalatnama.
No,
on
it's
behalf of-
okay, but that notice has to be served, no, upon the appellants. Notices have not been served upon the appellants.
Lordship, if I may check the record, and the case may be taken up after a few minutes.
Yeah. এইটো অলপ চেক কৰি চাবচোন এপিলেণ্ট বিলাকে নটিচ পাইছে নে নাই আৰু হেৰি অৰ্ডাৰটো টেগ কৰি দিবাচোন এপিলেণ্ট বিলাকক মানে নটিচ ইছ্যু কৰিবলৈ দিয়া অৰ্ডাৰটো উইথড্ৰয়েলৰ অৰ্ডাৰটো পাইছে নে নাই য়েছ আফটাৰ 21 অহা নাই যে মই চাই দিম Appellant is not represented today. This matter has come up for the first time after 28/2/2024. LCR is received. Lawazima Court's order dated 17/12/2024 reflects that notice has been served to respondent number 2 Notice has been duly served to respondent number 2. The respondent number 2 is also not represented today. Appeal has already been admitted. Registry to appoint legal aid counsel to represent the appellant as well as the respondent number 2. Okay, then we'll appoint a legal aid counsel. Nobody is appearing.
21.
21, Lordship. Okay. You are for the appellant.
Lordship, as per order dated.
So we will appoint a legal aid counsel for respondent number 2 and we'll fix it for hearing. Learned counsel Miss Agote litigation. What is your name?
Keyboard wizard.
Keyboard wizard.
On
Legal
behalf
aid
of-
counsel?
No.
Learned counsel.
Keyboard
Miss
wizard on
Keyboard-
behalf of H. Lordship.
On behalf of learned counsel
H.
Mr. H.
A. Somua.
Somua. A. Somua.
Yes.
A. Somua is present on behalf of the appellant. The legal aid counsel to Baki khini okol respondent number 2 e likhi diya. List the matter for hearing.
Yes.
LCR টো পাইছে না আৰু এটা চেক কৰি দিবা please. পাইছে বুলি লিখা আছে তথাপি আৰু এটা চেক কৰি দিবা.
May I please, your lordship? Lordship, kindly this matter may take after a week, lordship, because my
After
senior
a week,
lordship.
learned counsel Mr.
I
Ayush Chaudhary has prayed for adjournment. List the matter. You are for? Learned counsel Mr. A. Rosidi is present for respondent number 2 and learned additional PP Mr. P.S. Locker is present for the respondent state. List the matter. It has been admitted. We'll list it for hearing then.
No, lordship, IA is there, lordship, for.
Okay. List the matter on 12 June.
Deeply.
Your lordship, my lord, here the trial court record has come. But I think, my lord, it is
Not
against 138. 138. But here the case is, my lord, notice was given in a particular check number. Earlier, some checks were lost. I lost an FI. I informed the bank also as regards that. My lord, thereafter, 138 notice was issued where I informed that there is no such check lying with me. And my lord, after that, notice was issued to me. I have
We'll
come
fix it for admission.
fix it for admission.
I think also the notice it's not completed also because it
That's
is
not completed.
this is an order column receipt.
Okay.
Maybe also I have not gone through.
I haven't checked.
As it is 138 also.
Neither ID card nor any answer notice in respect of the respondent number 1 has been, no, not served. Learned counsel Mr. P.K. Roy Chaudhary is present for the petitioners. Learned additional PP Mr. P.S. Locker is present for the respondent state. Service report on respondent number 2, number 1. Okay, this is respondent number 1 now, huh? Okay, respondent number 1 is awaited.
My lord, can I make a prayer that let this matter come along with criminal petition 160124?
Okay, list this matter along with criminal petition number 1601/2024 after 1 week, 2 weeks?
My lord, after 1 week.
After 1 week.
Back to the leadership. Well, this item can be listed on Thursday, Milord.
Sorry,
Thursday.
Thursday,
Uh,
on Thursday?
My lord, Thursday, my lord.
Thursday or Friday? Friday.
Friday, I have some difficulty.
Thursday,
Friday.
part-heard matter.
Okay.
My lord, on Thursday, my lord, I am in the midst of a part-heard matter. So that may, my lord,
Next day, Milord. So we take over.
Up to you. You give me the date, I'll fix it.
Lordship, on 2nd of June.
second,
Monday.
after late, ठीक है ना? All right.
Second.
Good enough, because I am also not there. Today I'll take leave on Thursday and Friday. I'll be here on Monday.
I see.
As agreed by learned counsel for
Lordship is
both the
going to
sides. Is
hometown.
the matter on Monday, second June.
The lordship is going to hometown.
No, no, not hometown, Kolkata.
All very nice. God bless.
Item 25.
We had a opinion, Lordship. So, Lordship, there is a delay, Lordship.
Huh?
There is a delay, Lordship.
Condonation, na?
Lordship.
Oh, state of Assam.
State of Assam.
Against what? Conviction.
Acquitted against acquitted, Lordship.
And this is the acquitted accused. How many days delay?
That is not mentioned. It should take a significant.
See, even one day also you'll have to issue notice. This is the
Lordship.
accused. Learned additional PP, Mr. P.S. Locker is present for the appellant. Full stop, appellant to take steps to issue notice to the respondent. Appellant, not the applicant. A2 criminal petition 25 of 2025. Applicable. Applicant to take steps to issue notice to the respondent, list the matter or returnable within 4 weeks, 2 weeks.
4 weeks.
4 weeks. Returnable within 4 weeks, list accordingly. Okay.
Item number 26.
Written objection must be filed on behalf of the Superior Court.
Or written objection, 10 years, more than 10 years. Okay, we'll have to fight. Learned counsel, Mr. R. Setri.
Yes.
Yes.
N Milli on behalf of our secretary. N Milli on behalf of our secretary.
It's okay.
Okay.
Your name is also
Lordship.
there in the cause list. Learned counsel, Mr. N. Millie is present for the appellant. Applicant, learned additional PP, Mr. P.S. Locker is present for the respondent state. Learned counsel, Mr. D.K. Bhattacharya is present for the amicus, learned counsel, amicus theory, Mr. D.K. Bhattacharya is present for the respondent number 2. Full stop. The respondents have submitted for time to file objection against this application. List the matter after 2 weeks. 2 weeks.
Much obliged.
ID orders are of
27.
By order.
Applicant is not represented. Service report on respondent number 2 is awaited. List after 2 weeks. Learned additional PP, Mr. P.S. Locker to Kohadiba is present for the respondent state.
As per order dated 25/9, registry को सर्विस रिपोर्ट के बारे में दिया था, बट रजिस्ट्री अभी तक सर्विस रिपोर्ट दिया नहीं. जो कोर्ट से नोटिस इशू हुआ, बट उसके बाद भी लास्ट चांस दिया गया है। ये तो 29 सितंबर लास्ट डे हुआ ना, तो
My lord, in the
Yes.
present case, lordship, the appellant.
Pero I will respondent. Oh, 20. Oh.
We are responding.
I responded.
I am responding. I am respondent, lordship. Similar matters were filed, lordship. The fact of the case is this, lordship, that the RFA was earlier filed by the appellant, lordship. And those RFAs were dismissed by this honorable court, lordship.
Okay, okay.
And
Yes.
the dismissal order, your lordship will find. Order dated 21 October 24.
Order dated 21.
21/10/24.
Twenty-one, 10, 22.
21/10/24. That is similar matters, lordship. But,
Order, have you
take
annexed the orders?
order, lordship.
Similar matter and they are not appearing. But
Dismissed by this honorable. I am given the copy.
okay, but this are these appellants aware that notices have been served to have the notices been served to them?
In those two similar matters.
Notices were similar matters.
Similar
As
matters,
same
Lord.
cause of action.
Parties are same. Parties are same in all the. Only respondent is different.
I will also benefit if I dismiss, but actually the notice, there is nothing, no report of notice being
Lordship,
served.
the learned counsel for the appellant has appeared, filed his Wakalatnama. Thereafter, Lordship, he did not appear, Lordship, on behalf of the and he has submitted that he will withdraw his Wakalatnama, Lord. Thereafter, he is not a.
Appellants filed his Wakalatnama.
Yes, yes.
But then we had withdrawn.
Yes, yes.
Then after he had withdrawn, the registry had issued notice to the appellants.
Appellant.
These notice has not been served to the appellants.
But Lordship, actually, your Lordship may dismiss because there are two numbers of previous order. Only defendant is different, same conduct. I have given one of the copy, Lordship. Because prior to filing the present RFA, Lordship, the appellant has
They
filed.
in the earlier cases that notices have been served to them. Here notices have not been served. We'll take one more call. We'll issue notice. for the
Lordship, problem is this, while admitting the appeal, Lordship, the further proceeding of my suit has been kept at abeyance, Lordship. Since 2018, suit is under a stay, Lordship.
Suit is pending at which stage?
Suit, yep, for PW.
For PWs. I'll just check. Please, Aisla Nigeru. Sarwana, I know. Order kita kot na.
Ismail. Your Lordship, may please.
Yes, yes.
Your Lordship, may please to peruse the order dated 9/12/24 of the present proceeding, where last chance was given to the appellant. 9/12/24.
Applicants.
And there is also, my Lordship, one other order, 1st of October 24, that if the appellant does not appear, it will be dismissed. Appropriate orders will be passed.
Actually, they have not checked the records actually. The notice has not been served from the registry.
Then your order may pass.
Yes, yes. I'll give one more chance because here, you see here in this case, that here that order clearly reflects that registry had informed through a notice about the withdrawal, but no reply has been received from their end.
Lordship, may please to peruse the order dated 1st of October 24. 1st October 24. And again, the order was passed on 9th of December 24. Last chances were given.
Here, 25/9/2024, the indicates that notice issued to appellants numbers by informing them about, but the notices have been issued, but nothing about service. Office note dated 17/9/2024. I'll just check.
Notices were issued, Lordship, but it is not mentioned that whether it was served or not.
Notice 27/9/2024. Notice issued to the applicants has not been received back.
So it will be deemed provisional, Lordship. After 30, expiry of 30, it will be deemed that the notice.
It's there, but it should be through post office. Postal service.
Leave to your Lordship, but presumption is always that after expiry of 30 years, it will.
It's there, but it should be through postal. But this is usual process of postal service. I do not know.
Speed post, by
Speed
speed.
post. Okay, do you have the?
That is in the record. That is in the record.
Okay, then it can be considered as deemed to be served. Speed poster है कि नहीं भूलिए गया सब? Speed poster है no notice the issue poster speed poster. Speed poster. This is not to speed post. Not to speed.
No, it is there in the record. We have checked it. Even in the order, Lordship, dated
Yes, yes.
25.
We have.
Your Lordship, will please to peruse the order dated.
We have. For a speed post, by speed post. Learned Counsel, Mr. S.P. Roy, is
Lord.
present on behalf of the respondent, or respondent number 1.
Same order may be passed. It passed in the other
Okay.
similar matter.
Is present on behalf of the respondent number 1, full stop. It is submitted that the earlier advocate representing the appellants has already withdrawn, and the registry the registry issued notice to the appellants. So some notices were issued to the registry by speed post. Office note dated
17/9/24.
17/9/2024 clearly reflects that the notices were issued 17/9. It is 27/9, I think.
Order is dated.
17/9.
Office notice dated Lordship 17/9/24. None appears for the applicant on call. However, SP Roy Learned Counsel for the respondent number 1 and Mr. T. Chaudhary Learned Counsel for the are present. The office note dated 17/9/24 indicate that the notice was issued to the appellant number 127 by the SP's post on 18/6/24.
Oh, 13/9, it is 13/9. Office note dated 13/9/2024 indicates that notices were issued to the appellants number 1 to 7 by speed post. To the appellants to to the appellants about the withdrawal of learned counsel Mr. J.S. Sekia from representing the case further. Full stop. The appellants have not engaged a new counsel thereafter. This case has been fixed. For appearance of the appellants, stroke applicants, but they have failed to appear continuously since 25/9/2024, full stop. The order dated 31/5/2024 clearly reflects that the appellants have taken away the brief from the earlier counsel, Mr. J.S. Sekia. It is submitted that due to similar conduct of the appellants relating to another case number IA Civil 2445/2018. Their case has been dismissed by this court by order dated by a coordinate bench of this court by order dated 21/10/2024. Full stop. After scrutinizing the office note and the orders of this court, it is further submitted that it appears that this applicant is dismissed for non-prosecution. For non-prosecution.
And IML lordship may be dismissed. There is IA for condonation of the appeal that may be dismissed.
That कोई did ना I
Was-
that RFA was numbered, registered.
Wrongly numbered. Wrongly.
Okay.
Well, I beg apology, just 27 earlier item. I was in back code number 11. It took time for approximately.
27, I think.
Non-appearance.
Only appearance.
Appearance.
Present day.
Next
present-
Monday, next Monday.
Learned counsel, Mr.
A.K. Hussain.
A.K. Hussain.
It's a by order.
Oh.
Monday.
Is present लिखित लो इसे. Item number
27.
27.
But next Monday,
Next Monday.
Yes.
Next Monday it won't come.
Any date, your lordship on.
6 June.
6 June, maybe Idul Zuha, there is a dispute. So
Okay.
maybe close. 4 June. I'll let this.
May I please, your lordship? Also, during the pendency of this criminal division, he was arrested. His present petitioner was arrested and he was put behind a bar.
I had to give an essay.
I had to bail over an essay.
Okay.
The High Court order in page number 40, lordship.
Arrest only.
Hmm?
Arrest only. BA only. But if he is arrested or then BA has to be filed. Revision is for
Arrested?
BA.
Arrested means, lordship, when this criminal revision was pending, order is for page number 40, lordship. So his bail was not considered and court appointed after receipt of the LCR, his bail will be considered. In the meantime, he was arrested, lordship.
Okay.
4:30, no?
I had to give an essay.
ইটো আই আছিলে মানে সাসপেনশনৰ কাৰণে সেইটো কোৰ্টে কনচিডাৰ নকৰি নকলে যে এলচিআৰ আপলোড কৰিম বুলি ক'লে ইনফিনিট মেনেজ কৰিব
This revision petition is against conviction or
Conviction, yes, Lordship.
concurrent decisions?
Conviction, Lordship.
Conviction.
Conviction.
By-
He was convicted for 1 year by the learned CGM court. Thereafter, we prepared an appeal before the session judge. Session judge appealed the conviction. So we have prepared this criminal revision petition. And on the first day, court, we have filed another application for suspension of the conviction, Lordship. But court appointed the after coming of the LCR, his bail will be considered.
Okay.
So in the meantime, he got
You did
arrested.
LCA?
So I have not gone through it yet, but Lordship, if he is now arrested, Lordship, so for releasing him on bail, Lordship, that separate bail application has to be filed, Lordship.
I have been filed.
IAS for suspension of the
So suspension and also for bail also. This
Bail.
present, I
think bail.
I'll give you some time then. You check it after some time. Half an hour, after half an hour.
Okay.
You check it because I think you'll have to go through the records. Because we have received the records also, no? Records, you know, That's- May not be required also. Records may not 1 year only, may not be required. Just check.
Here it was said that interim will be considered after receipt of LCR. In the LCR receipt, but in the meantime he was arrested
Oh, okay, okay.
before the hearing, before
Oh,
this court,
okay,
my
okay.
lord.
Right.
He was arrested, my lord.
So this is on a different.
Oh, my lord, it was perhaps
Okay.
infectious, my lord, perhaps, my lord.
He was not arrested.
he was not arrested.
Okay.
IAS infectious, my lord. Suspension of file for suspension, my lord. In the meantime, he was arrested, my lord.
Oh, it was actually it was not before me, so I cannot remember.
That is
that
no,
I
no,
was
my lord.
asked to call for record or something like that.
But actually, it has to be considered automatically with the filing of this criminal petition because criminal revision petition because the section itself says that when it is admitted, revision is admitted, then his
Revision has been admitted.
but court has not passed it likewise, Lordship order also.
Notice, my lord, here perhaps he was also not in previous bill, my lord. That's why they have, although 1 year, my lord, they are not perhaps previous bill, my lord.
Why didn't you?
They have not applied perhaps in the
Why
court
didn't you
below
apply for previous
at the
bail
time
in the
of
lower court?
conviction, my lord.
Lordship,
Only 1 year.
Conviction report, you'll have to apply it
My lord.
first.
exactly, Lordship, we would have applied, but at the appeal was pending. After appeal the order, immediately we have
No,
filed,
no,
it,
no,
but
no,
we have
that
to
is-
file. We have to
There
file.
cannot be any.
Concurrent finding, that's why the court also perhaps issue notice and thereafter call for the LCR. And in IA, it was also considered that, my lord, it will be considered after receipt of LCR, trial court record, as it is the revision, my lord.
So there also, before any court, you could have filed for
Mine.
bail, previous bail. Even before the district judge also, you could have filed for previous bail.
Exactly.
And
Yes.
the revisional court has only limited jurisdiction, my lord. They cannot enter the merit of the case.
And then this story is also totally entirely different.
Mine.
He was not arrested.
My lord.
Now he has been
Arrested, my lord.
So orally we cannot take the submissions.
My lord.
You'll have to improvise it.
My lord.
And then this is under 430. Okay. You can file an additional affidavit or you can not press this or you can file another petition. It's up to you. You think about it, I'll fix a date. Which will be the proper way you think about it. 2-3 days.
2-3 days, Lordship.
Because here in this case, he was not arrested.
My lord.
This is the story in this case. So now orally I cannot take up the submissions. You'll have to bring it on record. In whatever manner you want to bring it.
Okay. 2 days may be given, Lordship, we will file.
When?
2-3 days, Lordship.
2-3 days, yes. Learned Counsel Mr. K.K. Hendig has prayed for adjournment, list the matter on 2nd June or agot, even before.
30 minutes. Definitely.
Item 29.
My lord, here is conviction under section POCSO 8. My lord, 6 months imprisonment, my lord. Here also they have filed IA, my lord, for
Yes, sir.
suspension, my lord. At this stage, lordship may issue notice, my lord.
Interim may be given, your lordship.
No, my lord, without hearing the.
No, LCR has also already been listened.
First of all, you have to know about the
Learned counsel, Mr.
Deepak Nayak.
AF,
K. Bhattacharya.
AFT. Your name is not in the cause list, learned counsel, Mr.
K. Bhattacharya, yes, sir.
K. Bhattacharya, okay. K. Bhattacharya is present for the applicant. Learned additional PP, Mr. B. Sharma is present for the respondent state. Petition applicant should take steps to issue notice to the respondent number 2. List the matter on. Meanwhile, call for the trial court records. 5th June.
My lord, they have to take step from the expert Deepak Nayak, my lord. They will have to
Yes.
take step by expert Deepak Nayak, my lord, for registry and thereafter public to represent the public.
You'll have to take steps to registry. Item 30 and 31.
No, delay. May I please?
Yes.
Your Honor, in this matter, the IA has been filed for condonation of delay. Condonation of delay of 932 days in filing the connected criminal appeal.
Learned counsel, Mr.
You, Chaudhary, legal aid counsel.
Present for the applicant. Learned counsel, Mr. B. Sharma is present, learned additional PP, Mr. B. Sharma is present for the respondent state. Applicant to take steps to issue notice to the
POCSO.
respondent number 2.
Yes.
To the registry of this office returnable on. Meanwhile, call for the trial court records. And then criminal appeal, I'll admit it.
No, my lord,
No,
the
no.
delay is 9.
Oh, delay.
Delay, there is a delay.
Delay, my lord.
After delay is to be called.
I was under the impression it's for
Fine.
bail. Okay.
Oblige.
Okay.
Wait, please, your lordship.
Dismissed.
Supplemented for this item 37.
Lordship, this matter was substantially heard by the Honorable Court. My submission at this stage will be my petition under Order 41 Rule 27 of CPC.
Or to bring evidence.
Lordship, this can be only decided at the time of hearing. This is the only guidance given by the.
This matter was remained part heard before the Honorable Justice Praveen Pukam matter. So kindly see the order dated 6/2/2025. 6/2/2025. So my lord, let the matter get taken up by the appropriate bench. Part heard since then.
This petition was heard by the Honorable Court only. This petition was heard by the Honorable Court on the last occasion. Thereafter, it was allotted to another court in bench. And as per order, it was again allotted to the Honorable Court. My submission at this stage. So Order 41 Rule 27 petition can be decided at the time of hearing. So that petition may be kept at the bench till.
That is why that order has, this petition was, RSA was heard. I think RSA was heard.
Heard.
No.
It was remained part heard before the Honorable Justice Praveen Pukam matter.
Once that
Order dated 6/2/2025.
You will file.
Actually, that matter has already been released. I think though
No, not released matter. This remains part heard. So let the matter be heard appropriate. Okay, Honorable Justice.
Learned counsel, Mr. B.K. Bhagavati is present for the applicant, and learned counsel, Mr. P.C.D. has submitted that this matter has been part heard by a coordinate bench of this court. List this matter before. This matter has
So many days it was hard one.
There is no specific such. There is a problem on also. Because then that LF.
This matter has been substantially heard by another bench and has submitted that the registry may list this matter before the appropriate bench who has heard the RSA. Registry to list accordingly. हो गया नहीं? बाकी नहीं ओके 2 PM में मानधन ऐसे नहीं ना यहाँ
Item number 34 there.
Come there, probably coming to come there.
Emotion चली गई.
18. So I'll come at 2 then. Somebody has asked for taking up this matter at 2, no? You have asked. Okay. So I'll come at 2.
Present respondent and the petitioners entered into an agreement for purchase of a plot of land. In this case, while we filed the criminal petition of 2019, there were 3 petitioners. And thereafter, during pendency, petitioner number 1 died, Lordship. So petitioner number 1 is the husband of the original owner, Lordship.
That died in pendency of which proceeding?
Criminal petition, Lordship. Thereafter, we prayed-
this proceeding.
Yes.
Present.
Yes, Lordship.
Okay.
Thereafter, we prayed for striking out the name of petitioner number 1. So at present, 2 petitioners are before your Lordship.
So petition number 2 and 3.
Yes, Lordship. The dispute is regarding a plot of land, Lordship. The original owner of the plot of land is the wife of petitioner number 1 and mother of petitioner number 2. Wife of petitioner number 1 and mother of petitioner number 2.
Wife of petitioner number 1 and mother of petitioner number.
So petitioner number 1
So
is
they are
the
one family, same family.
same family, Lordship.
Son
And
Father, mother, and
husband, Lordship. Inara Imran Ali and 2 others. Imran Ali died during pendency of this criminal petition, Lordship. And Inara Begum, daughter, Lordship. Page 2, your Lordship, kindly see.
Imran Ali, he's the husband.
Yes, Lordship, husband of the original owner.
Husband of original owner.
Yes, Lordship.
She is alive or died?
She also died, Lordship. There was a deed of agreement in between the husband of the respondent and wife of the petitioner number 1, Lordship.
Minwara Bibi?
Minwara Bibi, her husband entered into an agreement with wife of petitioner number 1, Lordship. As she was the original owner of the land. So we entered into an agreement, we want to sell the land and they want to purchase the land, Lordship.
Okay. This Inara Begum is daughter of petitioner number 1 and Tahidul is
Subsequent purchaser. We have sold
Okay,
sold out the land to Tahidul, Lordship. And this Minwara Bibi, her husband, Abdul Rahim.
Now you are you wanted to purchase.
No, Lordship, I am the owner. Petitioner number 2 is the owner. Petitioner number 3 already purchased.
So they wanted to purchase.
They wanted to purchase.
Agreement was executed between 2 of you.
Between my wife, now Lordship, petitioner number 1 also died. And between the husband of respondent number 2, he also died, Lordship.
Very complicated.
Yes, Lordship. 3 persons already died, Lordship. When the agreement was executed, all are alive. Husband of respondent number 2 wanted to purchase the land from the wife of, or Lordship, from the mother of petitioner number 2.
Petitioner number 2 is the subsequent purchaser.
Petitioner number 3, now petitioner number 2, as because
Okay,
petitioner
now
number 1.
petition number 3 is the subsequent purchaser.
Yes.
taken purchaser. So, and the original deed was executed between, agreement was executed between?
Between the mother of Inara Begum
Mother of Inara.
and husband of Minuara Bibi. That will be better if we say petitioner number 1.
Yes,
so there
yes.
is a confusion.
Husband of
Minuara Bibi.
That is better.
We should have written
So-
as late, Lordship.
Husband of Minuara. So,
So out of that agreement, Lordship, we have handed over the possession to the Abdul Rahim, that is the purchaser, Lordship, who wanted to purchase, Lordship, after payment of some amount, Lordship. Thereafter, Abdul Rahim also died and original owner also died. But it is their case that they have paid some amount to the petitioner number 1, that is the husband of the original owner, Lordship.
so after, then you handed over the possession to Minuara's husband
Yes, Lordship.
after payment of some money.
Some consideration amount, Lordship. And their case is that, Lordship, they later on again paid 70,000 to the Imran Ali, Lordship, husband of the original owner.
So Minuara's husband Abdul Rahim handed over after payment of some money. And what is their contention?
Their contention is that, Lordship, second installment was paid to the husband of the original owner, that is the Imran Ali, Lordship, in the year 2008.
Second installment was paid by whom?
Paid by Abdul Rahim. It was the case.
Paid by Abdul Rahim. During his lifetime.
Yes, Lordship.
To whom it was paid?
To the Imran Ali.
To Imran Ali. Okay.
Imran Ali.
Okay. During his lifetime.
Yes, Lordship. Page 20, I am reading the vernacular, Lordship, second paragraph. It is their petition, Lordship.
Okay, page 20.
145 proceeding was initiated by Minuara, Lordship.
Page 20, okay.
Yes,
Please
page
read.
20, second paragraph. ইতিমধ্যে উক্ত শরীফা বেগম মৃত্যুবরণ কৰে। So original owner, Lordship. তথাপিও 1 নম্বৰ প্ৰতিপক্ষ জনে দৰখাস্তকাৰীৰ স্বামী আব্দুল ৰহিমৰ পৰা নিম্ন জমিৰ বায়নাকৃত অৱশিষ্ট ৭৭,০০০ টকা যোৱা 15/4/2008 ইংৰাজী তাৰিখে গ্ৰহণ কৰি নিম্ন জমিৰ দখল বুজাই দিয়ে। So this is her case, Lordship, Minuara's case. Her husband paid the second installment to the husband of the Sharifa Begum, who already died, Lordship. My case is that, Lordship, Annexure 1, for a moment, your Lordship, kindly see. That certificate of
Annexure?
Sharifa, Annexure 1, page 12.
Death certificate.
That certificate of original owner, Sharifa Begum. 7/4/2017.
Okay.
So their statement is 2008, they paid the amount to Sharifa's husband. But when Sharifa was alive, why they should pay the amount to husband, Lordship? There is an agreement between Sharifa and Abdul Rahim only. So that is a wrong statement. They did never paid any second installment. After paying the first installment, when they did not pay any amount, then after death of Sharifa, we become owner, husband and daughter, Lordship. So we sold out the property to petitioner number 3. As they failed to pay the rest of the amount, we have again taken back the property from Minuara and sold out to Lordship Tohidul Ali. This is our case, Lordship. But Lordship, she filed an 145 proceeding, and in that proceeding, 145 proceeding was drawn up, and thereafter 146(1) attachment was directed, was ordered, Lordship. Page 31, Annexure C6 is the order sheets. After calling report from police, Lordship, It was initiated on 3/9/2018.
So that
145
respondent has initiated
145 proceeding. In
against you.
spite of lordship preferring and suit for specific performance of contract, they have initiated 145 proceeding, lordship. Ordership Annexure 6, page 31. CR received on transfer, peruse the police report, date for hearing fixed on so-and-so. First party present heard the first party at length. It is stated by the first party that second party has illegally take possession of the disputed land which the first party claims to have been brought from the second party. Dolil submitted in photocopy. Second party submitted a prayer petition for another date for hearing, next date fixed for hearing of both the parties and submission of written statement by the second party. First party present, second party submitted petition for fixing another date for hearing. Report from IO Matka is called for. First party present, second party also present, both the parties represented by the learned lawyers. First party bought the disputed land from Sharifa Begum. This is no sale deed was executed. It is already admitted by her lordship.
These are original orders. It's page 34, no?
Yes, lordship.
Okay. Yes.
So 145, 146 order is 30/11/2018. Page 32, last part, lordship.
30/11/2018.
Yes, lordship. First party represented by the lawyer.
Page
along with
36, no?
32 page.
Page 32.
Yes, lordship.
Oh, this is the printed one.
Type copy, lordship.
Copy. Okay, I'm checking the original one.
Original, lordship.
Okay, it's okay.
30/11, page 36, last part. First party represented by the lawyer along with his client and witness. Witness of the first party recorded. Second party submitted Hazira but on call could not appear before this court as an interim measure in order to prevent any breach of public peace, tranquility in the locality. I, Sri Chandan Borgohai, so-and-so, satisfied to draw up proceeding under section 145(1) and satisfied to attach the disputed land under section 146(1) of CRPC and instruct OC to act as per law. So against this order, lordship, we have preferred one revision. Page 38.
Yes.
Relevant paragraph, page 41. Para 8, lordship, the learned executive magistrate, after drawing the proceeding under section 145 CRPC, further proceeded to draw up the proceeding under section 146 CRPC, considering the report of the police that the opposite parties are trying to dispossess the petitioner. The police report does not reveal that there is any structure or standing props on the disputed land. The order of attachment passed by learned executive magistrate is an interlocutory order and the same has not reached its finality. Such interlocutory order cannot be interfered with. The order of attachment, though, is an interlocutory order, but it has a bearing on the parties. It will affect the right and enjoyment of a party over the disputed land. However, such order is required to be passed considering the urgency of the matter, as there is every likelihood of breach of peace and tranquility in the locality. The learned revisional code itself recorded that it is not an interlocutory order. It is an interlocutory order, but it reflected that the right and enjoyment of a party over the suit land, lordship. And it is very well known to everyone, lordship, if a right is and lordship touch, then it become intermediary order, lordship. That can be challenged in a revision petition, lordship. There are lots of judgment, your lordship aware about that. So my case is that, lordship, I am before your lordship under 482 only because that when she has alternative remedy of filing a suit for specific performance of contract, she would have preferred a title suit, lordship. Instead of that, she preferred 145. And there are lots of decisions which says if civil dispute, then 145 is not maintainable. It is the right forum, only the civil court, lordship. In this case, I am relying some judgments, lordship. 1997, 4 SCC, page 241, Krishnan and another, Lordship. The respondent may raise one question that second revision is not maintainable, Lordship. For that, I am relying these decisions, Lordship. And one is 2009, 3 SCC, 310 page. In both these judgments were relied in a criminal revision petition before 9/26/2018 before this court, and in a similar situations, Lordship. They are also 145, 146, and both the orders were set aside by this court, Honorable Court, Lordship, in Safikuddin case. And then another one, 2021, Supreme SC 628, Mitesh Kumar, I am relying, Lordship, in addition to those, Lordship. Now, 1997, 4 SCC, page 241, paragraph 10, Lordship. 10 to 14 discussions, Lordship. Paragraph 10, ordinarily when revision has been barred by section 397(3) of the code, a person accused complainant cannot be allowed to take recourse to the revision to the High Court under section 397(1) or under inherent powers of the High Court under section 482 of the Code, since it may amount to circumvention of the provisions of section 397(3) or section 397(2) of the Code. It is seen that the High Court has suo motu power under section 401 and continuous supervisory jurisdiction under section 483 of the Code. So when the High Court on examination of the record finds that there is grave miscarriage of justice or abuse of the process of the courts, or the required statutory procedure has not been complied with, or there is failure of justice or order passed or sentence imposed by the magistrate requires correction, it is but the duty of the High Court to have it corrected at the inception, lest grave miscarriage of justice would ensure. It is therefore to meet the ends of justice or to prevent abuse of the process that the High Court is preserved with inherent power and would be justified under such circumstances to exercise the inherent power, and in an appropriate case, even revisional power under section 397(1) read with section 401 of the Code, as stated earlier. It may be exercised sparingly so as to avoid needless multiplicity of procedure, unnecessary delay in trial, and protraction of proceedings. The object of criminal trial is to render public justice, to punish the criminal, and to see that the trial is concluded expeditiously before the memory of the witness fades out. The recent trend is to delay the trial and threaten the witness, or to win over the witness by promise or inducement. These malpractices need to be curbed, and public justice can be ensured only when trial is conducted expeditiously. Thereafter, some decisions were relied, and then finding paragraph 14, Lordship. In view of the above discussion, we hold that though the revision before the High Court under subsection 1 of section 397 is prohibited by subsection 3 thereof, inherent power of the High Court is still available under section 482 of the Code, and it is paramount power of continuous superintendence of the High Court under section 483. The High Court is justified in interfering with the order leading to miscarriage of
This
justice.
revision is under section 482.
482.
This is not a revision petition.
No, Lordship.
No, the maintainability is there.
Maintainability is there, Lordship.
This is not under 397, so there is maintainability.
Sometimes, Lordship, there may be an objection that it's a second revision, but we are trying to give it
No,
a
but
color
it's,
to criminal
not-
petition,
It's
Lord.
not revision petition, it is CRP,
Yes, Lord.
not CRRDP.
This is criminal petition, not criminal revision petition. But instead of going for 397, Lordship, we have preferred 482.
482. You
So-
cannot go for 397.
Yes, Lordship.
Second time you cannot go for 397.
Yes, Lordship. That is why the Supreme Court says under 482, it can be interfered with, Lordship. The second decision, Sakuntala Devi, is also same, Lordship.
Paragraph?
Paragraph 24, Lordship.
Okay.
And relying on these two judgments, Lordship, this criminal petition 926/2018 was allowed, Lordship. In that case also, I was appearing in Safikuddin case. Now, Lordship, latest decision 2021, that Mitesh Kumar, Lordship. Paragraph 37 onwards, Lordship. May I read all the paragraphs or just mark it?
Okay.
If the dispute is civil in nature, then the best forum is civil court, Lordship. And on that ground only, Lordship, this court were on 2020, Lordship, the state the revisional court's judgment as well as, Lordship, the order passed by the executing magistrate attachment order that was also stayed. This order dated, Lordship, 21/7/2020. It is in the file.
Order dated
21/7/2020.
Okay.
Yeah, it is there, Lordship.
Okay.
Stay was already
I'll
granted. So this is my humble prayer before your Lordship that this 145 proceeding may be quashed, Lordship, in the interest of justice, as already in the meantime we have sold out the property to third person, Lordship. I reserve my right of reply, Lordship.
Yes.
The matter actually was put to an end by order 21/7/20 by this honorable court.
Yes.
It was, the order was passed considering all entirety. It is provided that the impugn order of the divisional court being so and so, as well as the order of the trial court, be suspended till disposal of the present. Because, so it was the facility order, the petitioner's, prayer was allowed by this order. And, for this reason, because, so many things, Sir, it's always clear that this is the matter of especially of civil things. So we do not want any more time to be wasted. Lordship pass an order. The parties will be directed to approach the applicant.
Lordship.
Yes. Minimum
Lordship. Who is the aggrieved party he can approach? Either of the parties, Lordship. If they are claiming right title on the basis of any
So
deed
your
of agreement,
limitation will start from today? Or it will start from beginning?
specific performance, if any limitation is specially mentioned in the deed of agreement, then that will be counted from the deed of agreement. Because they are aware about the specific performance of contract, so in spite of that, Lordship, that may not be recorded, Lordship.
No, yeah.
Lordship.
Observation may be the parties may approach the appropriate suit.
Matilda. বেশি লম্বা নহব judgment and order oral লিখিবা Heard learned counsel Miss R. Chaudhary for the petitioner. Inara Begum and Tahirul Ali and learned counsel Mr. A. Alam for the respondent Minuara BP as well as learned additional PP Mr. B. Sharma for the respondent state. Arrayed as respondent number 1. Minuara BP respondent number 2 likhiba. This petition was initially filed by Imran Ali along with the other petitioners, but as the petitioner Imran Ali passed away, his name was deleted, and the present petitioners number 2 and 3 are before this court.
He was struck off as he died on 18/2/2020.
Name was struck off as he passed away on 18/2/2020. This petition is under section 482 of the Code of Civil Procedure 1973 within bracket, the CRPC for short. challenging the judgment and order dated 2/9/2019 passed by the learned additional session judge Gwalpara in criminal division number 74 of 2018, where under revision filed by the present petitioners was dismissed, affirming the order dated 30/11/2018 passed by the executive magistrate Gwalpara in connection with miss case number 63 of 2018. It is submitted that the wife of Imran Ali, Safika Begum was the original owner of a plot of parcel of land. Where is the description of the property?
Page 20, her name is there, Mito Sharifa Begum, Lordship. Page 20.
Parcel of land at measuring. What is the
Lordship, that is page 22, original vernacular.
that how much is the plot?
6 বিঘা 4 কঠা 4 লাস
At measuring
6 বিঘা 6
4K
4 লাস 4 লাস page 22
4L appertaining to old patta number 391, no?
319.
319.
Yes, Lord.
And new patta number 493 under DAG number 64 old or new
64 old
or 64 old
and new 95.
DAG and comma didia DAG stroke didia and DAG number 95.
In vernacular it is 95, but in transcribed copy I have written 96 maybe.
I'll take the vernacular one.
Lordship.
95 new.
Lordship. DAG number 95 na 96.
The dispute arose when the dispute arose when nalage. It is I have considered the submissions at the bar. Full stop. It is submitted on behalf of the petitioners that a deed was executed between the original owner, no?
Original Sharifa Begum and wife of husband of Minwara Begum, Lordship.
Original owner and the respondent number 2 and the respondent number 2's husband. Agreement was executed, no?
Yes, Lordship.
Deed no agreement. Agreement was executed between the original
Deed
owner.
of agreement
Sorry,
for sale,
Begum.
Lordship.
Deed of agreement for sale was executed between Sharifa Begum and
Abdul Rahim,
Abdul Rahim,
husband of Minwara Begum.
hyphen Didwa, husband of respondent number 2 Minwara Begum, for sale of land, for sale of the for above mentioned land. Full stop.
On Lordship 31/3/2007.
On 31/3/2007. Full stop. On part payment of the amount of rupees, how much? 1,40,000?
No, Lordship. They have already paid. There are two, as per their allegation, 70 was given to the petitioner number 1, Inara Begum.
No, their allegation for a consideration of for a consideration of rupees
No,
1,40,000.
on the date of execution, 70,000 and later on 70,000 to the husband of the owner, Lordship. It is their allegation, Lordship. So in total 140, Lordship.
1,40,000 for a consideration.
Page 20, your Lordship.
Agreement
will
was
find.
executed.
Page 20, your Lordship will find.
The land was handed over to the.
On that date, Lordship, land was handed over. Later on, it was taken back by the original owner.
On that day, on the date of execution of the deed, the land was handed over to the purchaser. Abdul Rahim. After payment of rupees 70,000 in part. full stop. It is, however, alleged that the remaining amount of rupees 70,000 has been paid by Abdul Rahim to
Imran Ali, husband of Sharifa Begum.
Imran Ali, husband of Sharifa Begum. Full stop. It is submitted
On Lordship 15/4/2008.
on 15/4/2008. But the petitioner's side, instead of handing over their absolute possession over the plot of land, took back the possession of the aforementioned plot of land and handed over the possession to Tahirul Ali. Full stop. On the contrary, it is submitted on behalf of the petitioners that the respondent as well as the respondent's husband failed to pay the remaining part of rupees 70,000, and this is why the possession of the aforementioned parcel of land was taken back from the respondents and the land was sold to Tahirul Ali.
Tahidul Ali. As Sharifa Begum was no more Lordship, so we became
Respondent number 2, Tahirul Ali. Full stop. It is further submitted that it has been that the submission that the amount of that the remaining amount of rupees 70,000 handed was handed to Imran Hussain cannot be accepted, as at the time when the amount was handed to Imran Hussain, the original owner.
Imran Ali, Lordship.
Imran Ali. Imran Ali, the original owner,
Was
Sharifa-
alive. He was
Sharifa
alive.
Begum was alive, and annexure, what is the
Annexure 1 hard death certificate, Lordship.
and the
He
annexure
only
1,
died in the year 2017.
annexure 1 clearly reveals that the original owner, Sharifa Begum, was alive at the time when the part payment was allegedly handed over to Imran Hussain. That is on, what is the date?
8/5, Lordship, 8/5/2000. 15/4/2008.
15/4/2008. Full stop. The date of death of Sharifa Begum is clearly reflected as 7/4/2017 in annexure 1 of the petition. In annexure 1 of the petition. Full stop. It is further submitted that when the respondent had when the respondent could legally claim for her right over the right over
Right for
specific performance of specific performance of contract. At the strength,
If any such agreement was there, Lordship.
at the strength of any alleged agreement executed between the vendor and the vendee, it was the duty of the respondent number 2 to bring up a title suit for
Specific performance
of contract. However, full stop video. However, the respondents preferred to approach the
145.
preferred to
File
bring-
145.
to bring up a proceeding under section 145 of the CRPC,
Lordship. Which is clearly abuse of the process of the court, Lordship.
which is which is clearly abuse of the process of the court. Full stop. Where is the order? Page.
This 3011, Lordship, page 32.
The learned executive magistrate, Gwalpara, no?
Yes, Lordship. Our case is that the learned executive magistrate ought to have direct the parties to approach the civil court, Lordship.
The learned executive magistrate Gwalpara by impugned order dated. This is the impugned order, no?
Yes, Lordship, 30/11/2018.
30/11/2018 in connection with Miss
63/2018.
63/2018. Attached the aforementioned plot of land
Mentioned in page 33 also, Lordship.
after apprehending breach of public peace and tranquility. So, sir, against this order, the petitioners preferred the criminal revision number 74/2018, but the revision petition was dismissed
On 2/9/2019.
by impugned order dated 2/9/2019 in connection with revision petition number 74/2018, criminal revision case number 74/2018, by upholding the view that there is indeed
Page 41, last paragraph.
indeed apprehension of breach of public peace and tranquility in the locality. This attachment was passed after taking evidence or not?
After taking the police report and PW1, Lordship. Statement of the petitioner, it is mentioned in page 9.
It is fairly, it's okay. It is fairly submitted. Okay, I'll record your submission also.
Understand.
It is fairly submitted by the learned counsel for the petitioners that
Respondent, Lordship.
or by the learned counsel for the respondent number 2, that the respondents may prefer and I'll write fairly submission or I'll dispose it on contested by dismiss by allowing the revision.
Observation is part of the approach.
Okay. It is fairly submitted nalage. The learned counsel for the respondent number 2, per contra, the learned counsel for the respondent number 2 has submitted that there was indeed an agreement for sale and the aforementioned plot of land was attached after recording evidence of one witness and on the basis of police report. The learned counsel for the petitioner has relied on the decision of the Honorable Supreme Court in, I'll take the last only.
Shafiquddin, Lordship. 2021, Lordship. Shafiquddin, Lordship, by our High Court, the exists similar situation, 145, 146 proceeding. There also a direction was given to approach the civil court if so advised, Lord.
This Vitesh Kumar's judgment will be better, I think.
Lordship.
Has relied on the decision of the Honorable Supreme Court in Vitesh Kumar J. Shah versus the state of Karnataka and others reported in 2021-0 Supreme within bracket SC 628, wherein it has been observed that para 37.
37, Lordship, 37 onwards. There are 38 also, the dispute between the parties could at best be termed as one involving a mere breach of contract. Now, whether and what is the difference between a mere breach of contract and an offense of cheating has been discussed
Para
in the
37, para 38, another para, which one?
whether the dispute is one of entirely civil, that is para 41, Lordship.
Para 41. para 41.
Then finding lordship para 45, applying this dictum to the instant factual matrix, it can be safely concluded that the present case clearly falls within the ambit of first, third, and fifth category of the 7 categories and listed in the above said judgment. The case therefore warrants intervention by this court, and the High Court has erred in dismissing the petition filed by the appellants under Section 482 CRPC. We find that there has been attempt to stress the contours of a civil dispute and thereby essentially impart a criminal color to it.
Okay, very liquid one. I have also relied on the decision of the Honorable Supreme Court in Mitesh Kumar's case Supra. In this case, the dispute is relating to the plot of land, to the aforementioned plot of land, full stop. It is not clear who is the owner of the plot of land vis-a-vis who is the possessor of the aforementioned plot of land, full stop. It appears that it is clear that the petitioner ought to have taken have approached the civil court.
Respondent.
The respondent ought to have approached the civil court where the respondent would have where there was civil court instead of approaching the
145%.
Instead of bringing up a proceeding under section 145 of the CRPC.
Civil court is the appropriate forum for lordship for them.
Thereby, the orders dated so and so in connection with civil division number 11 and the orders dated so and so in connection with Miss J case number, Miss case, no?
Lordship, I have to quash the entire proceeding. Miss case number 63/2018.
Okay. Thereby, the entire proceeding of Miss case number 63 of
2018
is hereby set aside and quashed with the petitioner, the respondent is at liberty, okay? Respondent is at liberty to approach the civil court for relief.
If so advised,
If so advised, yes. And then the revision set aside, you don't want the revision to be set aside?
Yes, lordship,
Set
revision
aside the
and
revision লিখি দিয়া.
yes, lordship.
And set aside the revision 74 নে কিমান আছিলে? In terms of the
In my
above-
prayer portion, I have written clearly, lordship.
prayer portion to separate. In terms
Judgment
of
dated
the above
2919 in
observation-
criminal revision as well as the order passed in the Miss case 63/2018.
It's okay, sir. This petition stands disposed of.
Lordship. Revision
Anything
petition petition is allowed, lordship.
Yeah,
Lordship.
allowed, disposed of.
Lordship, obliged.